Even though she was living outside of the U.S., Maria still may qualify for VAWA. That's great. But what would be the difference, if any, if she were living in the U.S. but did not have legal status?
Okay, good question. If she was in the United States, so let's say she got here, whether she got here legally through a visa or her husband filed for her to come, or she entered here illegally, married a U.S. citizen, and has the same situation. So point is, she didn't have to make this long trek from Guatemala to the U.S. and present herself at the border because she was already here. However, she got there. How is that different? Well, she wouldn't be filing for asylum. That's number one. Because she'd be in the country likely more than 1 year. She would likely not qualify for asylum. So her option would be VAWA only, number one. Number two, she likely wouldn't be in removal. So that means she wouldn't have to go to court. So the process would be easier. Remember, VAWA is a subset or a very similar to a family-based application. In a family-based application, here it's her husband, you need to first document that the relationship is legitimate, that they married for the right reasons, not just to get immigration benefit. And secondly, that her change of status, where she goes from either an immigrant overstay or an illegal entry to a lawful permanent resident. VAWA has the same criteria, but adds that she suffered extreme cruelty. Now, if she's in removal, she can't file both components at the same time. In a family-based application, you're filing Form I-130, and then you're filing Form I-45. Now, there's a lot of other forms. It's not just two. But those are the two big ones. Document the relationship is the I-130, and then the change of status is the I-45, because VAWA allows her to file inside the United States, even though she might have entered without inspection. That is not the case in a family-based application. So I've just confused everybody. Let me try to back that up a little bit. When someone files for you, a relative, parent, spouse, or child, again, you got to document that the relationship is legitimate. The second is your change of status. Now, that could be either inside the US or outside. If you're inside, well, you don't need a waiver, generally speaking, and you're going to get employment authorization. If it's outside, you might have to wait for a visa. You might have to travel out. No, not might. You will have to travel outside the United States. And sometimes you need a waiver before you file. So the process is longer. It becomes more expensive, and you don't get employment authorization while that happens. In a VAWA scenario, that almost never happens. You always will be able to change your status in the United States. You may not get employment authorization right away, only because you might not yet be able to file for that second component. And that's what happens when someone's in removal. You can't file for both stages at the same time because you're dealing with two different agencies. So USCIS will adjudicate the document, the relationship part, but they can't approve. When I say adjudicate, I mean approve or deny. So the USCIS can't approve or deny a green card because you're in removal. That goes to the judge. So if she's inside the United States, she's when this happens, right? Because in both scenarios, she's now inside the United States, but in one, she presented herself at the border and say, hey, I'm afraid to go back. And in the other one, the question you just asked me, she's already here. So we're not filing for asylum. We're only talking about VAWA. And in the VAWA situation, if she's already here, she's going to get employment authorization. She's going to be able to work right away. She's going to be able, her process might still take 2 or 3 years, but there's no judge involvement. There's no trial. Now, if she's in removal, so the scenario where we're in now, she presented herself at the border, she's going to file the I-360. That's the form that documents the relationship and proves that she suffered extreme cruelty. That's going to get adjudicated by USCIS. Once that gets approved, she could request employment authorization. But put that issue aside for a moment. Once that's approved, she has a choice. She can ask the judge to remand the case back to USCIS, so get her out of removal, and then file the I-45, the change of status. Or she could file the I-45 and go forward with a trial in front of the judge. Now, she might request remand and the judge may deny it. Probably not in her circumstances. But again, this assumes that component, the I-360, gets approved. It's not automatic. It's not simple. Sometimes it takes a long time. And I really hope she has an attorney who's done it before. Because doing it without an attorney is not impossible. It's just difficult because there's no room for error. If you make a mistake and your case gets denied, you might get deported. You might not get a second shot. Whereas if she wasn't in removal, if she gets denied, she could just file again, or she could appeal it. Not that she can't appeal it when she's in removal, but again, there's less room for error. So I would almost suggest the case get remanded down, because then she's no longer in removal proceedings. If for whatever reason the officer denies it, well, they might put her into removal, but then she gets a second shot at it. And then she gets an agency that evaluates it and will give her a decision, essentially telling her, hey, here's why we think there's a problem here. Here's why we're denying your decision. And now you can fix that to the extent that it's fixable. So I'd much rather get it out of the courts. There's a backlog of almost 2 million cases in the immigration courts. The delays are catastrophic. The level of mistakes that I am seeing by judges and the court is, I've never seen it in any court in the country. Not federal court, not state court, not municipal court. It is the most dysfunctional system I have ever seen. So absolutely anything I can do to avoid the courts, I will. Because I can't predict their outcome. What they did yesterday, they might not do tomorrow. Even if they want to. I mean, we're seeing decisions by judges on motions we never filed. We're getting changes to court appearances without any notice. It's just complete chaos. You file a motion, you don't get a decision. You call the court, no one calls you back. You write a letter, no one responds. It's completely and totally broken. So to the extent we can avoid it, we do. And that's the major difference, is being in removal. And being in removal today with a dysfunctional court system means sometimes we have to have hard conversations with clients and they're like, are you kidding me? You must be lying to me. No court would do that. Well, unfortunately, that is the problem, is we're having erratic decisions by sometimes erratic judges, not purposefully. I'm sure some of them are really doing their best that they can, but it is a broken system.